of any nature in this matter, my lord. My case before Lordship is, my lord, that petition itself cannot be entertained at all.
If I can take just 5 minutes of your Lordship's time.
If it were, my lord, if your Lordships were to come to a conclusion that we are supposed to file our counter and, my lord, file material, we'll file all those material. But there cannot be any interim order of this nature. As the Supreme Court said, my lord, it's always open to file any petition.
My lords, if I can take just 5 minutes in rejoinder. My lord, there are three basic errors in the Learned Advocate General's submissions, and I'll state straight away what they are. My lord, when Lalita Kumari and Charan Singh talk about a preliminary inquiry, they talk about a preliminary inquiry by the investigating police officer. The inquiry is when the complainant gives the complaint, the first information to the police officer concerned. Before that police officer registers the FIR, he has to conduct a preliminary inquiry. Learned Advocate General is going on the basis that the complainant, which is the government, had an inquiry before they filed the complaint. That is not Lalita Kumari's case, that the complainant must have an inquiry before they file the case. Lalita Kumari and Charan Singh say that when an FIR is received, here the FIR is received from the government only on 18th December. The officer receiving the FIR has to conduct a preliminary inquiry. What the Learned Advocate General is saying is that the government, before they filed the complaint, had an inquiry. That is nothing to do with the ratio of Lalita Kumari and Charan Singh. It's like saying the complainant made a preliminary inquiry before he filed the FIR. Therefore, no inquiry is required thereafter. It goes totally against the judgment. But the question is, after the FIR was received, was there an inquiry before registering it? Not whether the government, before they filed the FIR, inquired within themselves whether they should file the FIR. That is not the inquiry there. That is point number one. It's a basic error, my lords, in the law, stated by my learned colleague.
Page 20 last, my lord, it was given on 1810. Page 20 last.
1810 to the government.
Enclosure 2.
Okay, my lord, can I just repeat what I'm saying? 1810 was the complaint that the government gave for the purpose of getting sanction. The FIR after sanction is presented to the police officer on the 18th of December. Please, my lord, see page 12. We can't look beyond the document. FIR.
There is no doubt about it.
18th.
Yes, yes.
That's it. My learned friend is saying 18th October. 18th October is when the government decided that they wanted to file a complaint and went for the governor's sanction. That is not the inquiry in Lalita Kumari. Lalita Kumari doesn't say that the inquiry conducted by the complainant before he lodges the complaint is the inquiry to be conducted.
The
inquiry to be conducted is by the officer to whom the FIR is presented.
Occurrence of offence, page 3, serial number 3, at page 12. Yes. This is, my lord, I only showed the enclosure 3, occurrence of offence, prior to 18/10/2024.
Yes, I agree with you. In fact, the occurrence, according to you, took place on 30th October 2023. That is according to you, the offence was on 30th October 23. But the point is, Lalita Kumari and Charan Singh say, when the officer who is to register the FIR receives an information report, before he registers that information report, he has to conduct a preliminary inquiry. That is the judgment. Not that the complainant has to conduct an inquiry before they file an FIR. The Learned Advocate General is going on the basis that the complainant conducted an inquiry before filing the FIR. That is not the inquiry contemplated in either Lalita Kumari or Charan Singh. The inquiry is that when the investigative officer received the FIR on 18th December at 5:30, that inquiring or that investigative officer, did he conduct an inquiry before 19th December to register the FIR? That is the test. Not that the government conducted an internal inquiry, they conducted an internal inquiry, then they went for sanction. They are the complainant here. The government is not the investigative officer. So their inquiry is the inquiry by the complainant, in which case Lalita Kumari and Charan Singh become totally ocious. They're not worth the paper they're written on. We run a coach and four through them. So, my lords, my learned friend, referring to how the government conducted internal inquiries of no relevance. Question is, did the investigative officer, when he received the first information report, when there was a delay of more than 3 months, when it was a matter of corruption, did he conduct a preliminary inquiry to see whether that complaint made out an offense? That is number one, the basic error. Number two, the basic error made by my learned friend, the learned advocate general, is this. Your lordship asked him a pointed question. Where does your FIR make out the ingredients of 13(1)(a)? His answer was, the investigation will disclose that. I'm sorry, my lord, but the law is very clear. If the FIR does not disclose in itself the ingredients of an offense, that is a ground for quashing. That is Bhajan Lal. In which case, let them conduct a further investigation. That is why we have a preliminary inquiry. That is why Lalita Kumari said there must be an inquiry before you register it. If they had had that inquiry as is contemplated, then what my learned friend is saying, we would have found material to make out the ingredients. I can understand. The two are connected. So my learned friend saying the purpose of investigation is to find the ingredients is wrong. A criminal case is not a fishing expedition. The ingredients are made out. Purpose of investigation is to garner the evidence. The purpose of investigation is not to find the ingredient. My lord, ground for quashing, first ground for quashing is the FIR does not disclose a offense. The averments in the FIR do not make out the ingredients of the offense. When that is shown to my lord quashes that FIR is quashed. Because that FIR does not. The answer to the learned advocate general is, my FIR need not show the ingredients of the offense. My FIR shows I have a suspicion, so I want to investigate to find the ingredients of the offense. Well, that's a basic error. Well, it's a third basic error which my learned friend has made is about the issue of the stay of an arrest. Although I'm saying I want a complete stay, but your lordship's court, coordinate bench, this matter has already been decided at page 156. Page 156. The order starts at 154, 156. May I just read this, my lords? Counsel representing so-and-so would contend that the contents lack the ingredients